Curious about what the difference between a mitigation and a contested hearing is? Stay tuned and learn more. Like I said in the intro, talking about the difference between mitigation hearings and contested hearings in the state of Washington. And for those of you who do not know, my name is Tony Garguile. I am a local traffic ticket attorney in Washington State, based out of Tacoma, but I do tickets basically throughout the greater Puget Sound. Have done over 12,000 tickets over the past 9 years. And topic today, like I said, we're talking difference between contested and mitigation hearing. And this is something that so many people confuse. And what's actually surprising, over the past 10 years, there's data on, what people do with their tickets. And over the past 10 years, there's actually more people that request a mitigation hearing as opposed to a contested hearing, which is kind of boggles my mind a little bit. And I think the large reason for that is that people don't know the difference between the two. So I wanted to do a video on the difference. So many people confuse these two types of hearings, but let's give you a little background, a little more background. When you're given a traffic ticket in Washington State, you have three options available to you. First one is to pay it. Second one is going to be to mitigate it, and the third one is to contest it. So what is the difference between a mitigation and a contested hearing? A mitigation hearing is a hearing to determine whether there were mitigating circumstances surrounding the traffic infraction in order to decide whether a reduction in the fine will be granted by the judge. Now, when you request a mitigation hearing, the infraction will, let me repeat, will appear on your driving record. You are only hoping for a reduction in the fine that you are supposed to be paying to the court. If you want to argue the facts or assert, for example, that the cop must have had your speed wrong, this is the wrong type of hearing. Now, a contested hearing is one to determine whether you committed the infraction. And by requesting a contested hearing, you are stating that you did not commit the infraction, or you want the city or state prosecutor to prove that you committed the traffic infraction. So once again, if you are okay with the ticket going on your record and you are only seeking a reduction in the fine, request a mitigation hearing. If you actually want to fight your traffic ticket and want the state or city prosecutor to prove that you actually committed the infraction, you want to contest the traffic infraction. The only way to keep the ticket off your record is to request a contested hearing and win at that hearing, or by working out a deal with the prosecutor at the contested hearing where the prosecutor agrees to reduce the ticket down to a non-moving violation. But super important, if you want to keep the ticket off your record, do not do a mitigation hearing, okay? If you have questions, feel free to reach out to us. Our number is 253-201-2001. We are happy to walk you through your options. Or you can find us online at MrTicketFixer.com.